I think we'll go ahead and call the meeting to order. Lenny, would you call the roll?
Conrad. Here. Vogel.
Here.
Jansky.
Here.
Woodhull.
Here.
Spear.
Here.
Michael. Absent. Black. Presley. And the fourth.
So we are in order. We have a special kind of workshop approach to the first part of the meeting tonight, where we're going to be hearing from Ken Down in connection to proposed amendment to the planning board pursuant to City Code 325-40 (A). Before we enter into this conversation, I'd like to make some general comments to kind of frame our discussion. And I've actually committed this to writing because I wanted to select my words very carefully on this particular topic. Welcome. So forgive me if I read from my notes. And the Common Council referred the proposed zoning code amendment to the planning board pursuant to City Code 325-40 (A) and requested an advisory opinion. Over the past several weeks, we've received substantial material from a variety of perspectives, including Common Council, interested citizens, and the applicant. We've also reviewed recommendations from the Columbia County Planning Board. I appreciate the time and effort that each party has devoted to helping us understand the issues. I would also note that public comments are not a part of the regular meetings for the planning board and usually reserved for the public hearing period during the application review process. So there won't be public comments tonight in association with this agenda item. I think everyone recognizes that this matter is significant, and so much so that that's why I've committed my thoughts to writing. The issues are complex, the stakes are high, and it is likely that the city will continue addressing the questions surrounding the waterfront and this section of zoning code for years to come. One thing I've learned over many years of public service is that communities are best served when they invest in strong decision-making infrastructure. Clear roles, clear procedures, clear standards tend to produce better decisions over time than focusing solely on the controversy that happens to be in our face today. And I believe that's where our opportunity is in this discussion tonight. Our task is not to resolve the broader controversy. Hi, Sarah. Others have those responsibilities, including the Common Council in its legislative role and, where appropriate, the courts in their judicial role. Our opportunity is narrower, but I believe equally important. We can help strengthen the city's decision-making process by remaining disciplined in our role and providing constructive advice from the perspective of the municipal body, that is the planning board, the municipal body that will ultimately administer this section of the zoning code. With that in mind, I'd like to suggest that we focus our discussion after Ken's presentation, that we focus our discussion on the question that I believe is uniquely within our board's remit. And here's the question. Does the proposed amendment provide clear, objective, and administratable standards that future planning boards can apply fairly, consistently, and predictably? I don't believe that our discussion today should become a reconsideration of the conditional use permit, the pending Article 78 proceeding, or the broader policy debate surrounding the waterfront. Nor do I believe that we've been asked to determine what occurred at the dock in 2011, or to resolve the competing legal interpretations that may ultimately be addressed elsewhere. Instead, I hope we focus on questions such as, does the proposed language provide sufficient clarity for future administration? Are the standards objective and capable of consistent application? Would future applications and planning boards understand what evidence and findings would be required? And are there provisions that would benefit from additional clarification or definition? If we can answer those questions thoughtfully, I believe that we'll provide the Common Council with something that only this board can provide: practical advice from the body that will be responsible for administering whatever legislation the council ultimately chooses to adopt. Before I ask Ken to begin his presentation, I just want to kind of poll the board. Is everyone comfortable containing our discussion within the parameters that I've defined? Is that something that we're comfortable with? Yes. Or,
I understand what you're saying, and I think in other situations that may be applicable, but here, I don't know if we can put our blinders on
Yeah.
and only look at the new code, because you're saying don't look at it thinking about the past or the future, past litigation or future litigation, when to me, this seems a direct consequence of past and present litigation and
Right.
planning board. So I just don't, I don't see how you could do what you asked. When I think this is a direct consequence of that. It's not like the city was just reviewing and said, oh, wow, this part is vague. I mean, they're specifically doing this in response to that.
so may I respond?
Yeah.
I've asked that question too. How do you separate the process from the content? And the difficulty I'm having is not each of us as citizens has a point of view, and maybe in some cases, strong points of view. But when we put our planning board hat on, what is the scope of our lane? And much of the issues that are addressed in the content are really not a part of the planning board's lane. It's not a part of our remit, not a part of our assigned responsibility. We are not convened to have an opinion about job opportunities in Columbia County. We may care deeply about that as persons and as citizens, but it's really not a part of the voice of the planning board. So that's where I'm having difficulty on
The
this.
new code wouldn't have anything to do about employment. I mean, what you've said doesn't make sense to me, because if this is adopted and Calvaruso's does come back to us, we will then be taking it and applying it to Calvaruso's. So what you said is like the exact opposite of what will happen. I'm not following.
Other comments?
I just had like a rather narrow one, which is that we're being asked to consider something that would narrow the planning board's authority to make findings of facts. And it's, I think, along with what you said, that that's part of our, whether we should recommend that or not. Is my understanding of what is the.
Peter?
Yeah, but I feel like I keep returning to the moment, maybe one of the last meetings, Andrew, or conversation we had about the authority that the planning board has, and I try to keep it all in the comprehensive plan. You know what I mean? So when I think about how I might be useful with my planning board hat on with regards to a local law, I think about the ways in which the comprehensive plan either creates permission for this kind of law, or the law aligns with the comprehensive plan, or does not. So that's the way that I'm addressing it. Is the local law something that is oriented with the shared vision for the city of Hudson that's encoded in the plan? And so I feel like I heard that in what you said, that there is a North Star for the planning board, and it's in the comprehensive plan. And the details are mystifying, and maybe for the common council to unpack, but directionally, I guess I'm just referring to the comprehensive plan and the shared vision in there.
One thought I'm having, Veronica, is that the concerns that you might express, because you have already expressed them in our last meeting, or started to express them. Those views are being expressed elsewhere. The county has kind of gone into a lot of detail about their concerns. So the common council will hear those very concerns that you might want to personally express yourself. But when I look at the language in the proposal, I find certain things to be kind of ambiguous. And how would a planning board verify certain requirements? They talk about truck trips. Well, what is a truck trip? Is that one way, or is that two ways? Is that empty? Is that only loaded? So in my view, if a future planning board has this law, I would want it to be more articulate in terms of expressing quantitative measurements rather than qualitative judgments. So that's what led me to conclude, since your concerns are being voiced elsewhere, let's concentrate on the, I have trouble with the word administrative ability to manage whatever they bring to us as legislation. And we're not a legislative body, so that's the other reason I was thinking, well, I'm not even sure why they're asking us, but they've asked for our opinion, so. Shall we just jump in with Ken and then we can pick up the discussion? I've just had a footnote. We have a hard finish at 6, so it's going to be a pretty tight discussion. Because we do have a public hearing scheduled with another applicant. So, Ken, thanks for coming tonight and reporting comments.
Where do you want me?
Right there.
Okay. First thing I want to say, Veronica, I think you're completely on target with one very important point, is this proposed law is entirely in response to the current situation where the planning board did issue a conditional use permit that is being litigated. And in all likelihood, the only time this would come into effect would be if the court determines, makes a determination in favor of the petitioners, the likely remedy would be to remand it back to the planning board for further consideration. So that's exactly what it is designed to do. So the situation, as I said, there was the planning board issued a conditional use permit in relation to the dock back in the fall. And there was litigation commenced afterwards, and it really hinges on a particular phrase in the zoning code, which is in the definition, and in 325.17 D1, the definition, it goes on, it says that the conditional use permit may be issued for, quote, continuation of existing commercial dock operations for the transport and shipment of goods and raw materials. Then it continues on and it concludes in the last part of that long sentence describing it. Such commercial dock operations as such uses existed on the effective date of this local law number 5 of 2011. That is the whole thing that the litigation hinges on, is that the code has a very specific piece of language in it referring to as such uses existed in 2011. The planning board's conditional use permit made no reference whatsoever to the past. And the litigation argues that that was an invalid. There was no conditional use permit. The litigation argues there's no conditional use permit that is authorized by New York, by the City of Hudson Code for dock operations. What it is an authorization for a conditional use permit for dock operations as such use of interest. And that's the litigation claim. If the court rules against the petitioners, this law will never have any effect whatsoever, because the existing permit will have been issued and it will have been set back and just won't have any bearing on anything, and it will not come up again because the permit has been given. But if the court agrees with the petitioners and sends it back, they're going to send it back to the planning board in all likelihood and say, you need to address this part of the code that says as such use existed in 2011. So it's entirely, the common council could just do nothing. That is certainly an option. That may well happen. In that case, it would just get sent back to the planning board and the question would come before you. Presumably the court would direct you to address that clause, and it would be up to you to do that. So the issue is already there. And whether it comes back to the planning board or not is beyond anybody's authority and power here. It's in the hands of the court. So this is a contingency. If the court sends it back, the question is going to have to be addressed. And the question is it going to be put in your laps to address on your own? Or is the common council going to take some initiative to try to make that a clearer, perhaps simpler task for the planning board? Again, it could go either way. I honestly don't know whether they're going to proceed with it or not. But I think it's really important to understand that it's not creating a new problem. It's not creating a new question. All those things are in the past. If the question is posed back to the planning board, it's basically you're going to have to deal with it on your own or with this additional guidance by amending the code. Yeah, and that's an open question. So, but I do want to emphasize, it's not like this is coming up and putting new things in there. It's addressing a question that may come before it. It's going to have to be answered either by you on your own or by you with this additional code provision. And that's really what it's all about. And what happened is that members of the public collect a lot of information, submit a lot of historical data from a number of sources, which if it were to come to you, you would want to review on their original, you would go want to reference these documents, do the verification of all this data on your own. But members of the public presented a lot of information about information they were able to gather in the time period before and after 2011. But also, this is not starting from scratch, just coming up with a new idea or a new plan or a new set of anything. The entire point of it is only to work with what is already set out in the code. It's not someone coming and saying, we need to expand things, we need to restrict things, we need to do things. It's how do we answer the question and the provisions that are already in the code in an objective, fact-based, rational manner. And that's the point of this law. So a lot of it, section 1, the legislative finding of purpose is observations, information that's been accumulated, references to existing code. It's just laying the groundwork for why this might be something to be done. And, again, it's based on a couple of provisions they're just black and white in code. One is, referring to the best that use existed. The second one that is an element of it is section 325.29, which has to do with non-conforming usage, because all these laws predate the Colorusso acquisition of this parcel. So they're longstanding laws, they were just there. Section 3, and when section 325.17D was enacted in 2011, it was a few years before Colorusso purchased the property. The dock was designated at that time a non-conforming use. So that's clear, it's in the law. And as a non-conforming use, section 325.29 has provisions. It says it limits non-conforming uses to no expansion, but also nor shall any external evidence of such use be increased by any means whatsoever. So these are things that are already there, and they're all just laid out in the findings and purpose. It's like, this is the rationale for where we are. So with that background, what the rational fact-based means of answering that question. And the council is proposing one, and it's laid out in some length, some of the rationale and thinking behind it, but it is not created, there's no intention there to put any new restrictions in place.
They've said that a few times, but it says, here specifically that any type of non-conforming use shall not be enlarged, extended, or placed on a different portion of the lot or the parcel of land occupied by such use on the effective date of this chapter, nor shall any external evidence of such be used to increase by any means whatsoever. And then it also talks about the number of trips allowed and the tonnage of material per year. So, I think at last meeting, we quickly ran the numbers, and 10,000 truck trips would limit them to what they're doing now if you broke that down into less than a month. So how is that not restricting?
First of all, because the restriction that has been in place since prior to 2011 is no external evidence can be increased beyond what existed at that time. So the rationale is that at that time, what was, and this is all laid out in the rationale, the reason, the view that things coming and going, and such as evidence of the activity, that was already restricted as a non-conforming use to the tax. And that what were those numbers? Well, the evidence that the public members of the public put in was that it was about 5,000 and something annually. And so the argument is that that is already what was in place. And that since you couldn't expand you couldn't have any external evidence beyond that, that was the restriction at the time, and this is trying to articulate that in actual numbers. Not in concept. In concept, it's already there,
You keep saying at the time, what time?
2011.
Veronica, help me understand how this question is relevant within the scope of the planning board's purview.
I'm just
This is a legislative question, I think.
Well, but it is, but the thing is, in a way, it's not that legislative, because the point is, it is not trying to do new things. As I said, the restrictions are in black and white, and been there since 2011 or earlier. And so what this is trying to do is put meat on those bones, when it said it cannot, you cannot increase the external evidence beyond what existed at the time. Well, what was that? And this is trying to, make a rational determination. It can't be perfect because there isn't perfect information, but it's to avoid being arbitrary. We want it to be fact-based, numbers-based, and they have, the public put in a bunch of data that arguably allows an inference of a good faith, rationally based estimate as of 2011. That in this part isn't even really part of the law. This is background that would be in front of you, whether or not this law is enacted. Those provisions are already there. The data on the truck traffic, I'm sure that the public will present to you. So none of this is actually new. This is not being imposed. It is not new. It's all data and it's all law. It's all written in the code already. And the point of the law really begins with its section 2, which is what would the actual changes be. All of this other stuff is really just an analysis of looking at the history, citing express parts of the code and referring to actual data that the public has put in, but it is not creating that stuff, and it is not actually imposing it. So it's beyond that.
Ken, can we open this up to a more general discussion with the board? I'm just.
I just want to wrap up really quickly. So the idea is you would have that same information whether or not this law is passed. What this law does do, though, is it gives you specific numbers that would have the imprimatur of the Common Council. You could reach these numbers on your own, or you could come with the other ones, but they should be fact-based if you're going in this direction.
We wouldn't be able to come up with other numbers though.
Well, I don't know.
If this were to pass, right, like those are the numbers that we would have to use, as I understand the intent of the law. It's or not intent.
What the part that actually would go into the code is actually does not say that. What it says is the authority would include, this is the part A, the authority to issue permit means authority to approve commercial dock operations equivalent in nature and not exceeding the scope and external evidence of dock, including the annual truck trips, etc. But it doesn't have any numbers.
It doesn't part B though.
It doesn't part B, and what part B does, because part A, although it does not dictate any numbers, there is data. It says you can use this data, and you may use this data to come to these numbers. It does not say you must, because you may find different things. But what it also says is trying to accommodate changes and the fact that they have done mitigating acts. It says notwithstanding all those numbers from the past, you can go up to 10,000 round trips a year, which is about twice what the historical data was.
How was that number determined that would be like an appropriate, the 10,207?
That is kind of an estimate. I mean, that is a.
Estimate we saw.
It was trying to accommodate
That's why.
an increase that would perhaps be justified by the fact that they have put in some mitigating things. Without it, there isn't any. That actually is the thing that would perhaps allow them to. Again, if it comes before you, we don't know what you do, but it's possible based on the data that you would conclude a number of trucks up to like 5,000. It's possible. It's not dictated. The law doesn't tell you that, but there's data that you might find compelling and useful. And if that were the case, if you found that, you would have no choice but to limit them to that. What this does, though, is it's actually opportunity to look, but they've also done mitigating things. So even though we found all the data, even though we believe this is what the law would compel us to do, this was saying, well, that we're gonna let them go to 10,000 anyway because they've done mitigating things.
But it would not allow us to, as a finding of fact, determine that in 2011 they did 50,000 rates, for example. I'm just like, asking as a matter of law, I'm just like curious about it.
It would, because A just says, use these things. If you found it was 50,000,
Yeah, I'm just.
that would
I
be
have actually
justified.
no idea what.
No, the first one does not give any, it does not dictate anything. It says, because in the explanation, it's like, well, how do you judge as such use existed in 2011? Trying to find things that are actually measurable.
Yeah.
That you can apply objectively, and these are the things that came to light. There could be other ways to even evaluate as such use as existed, but we're trying to find an objective measurable thing, and in light of the, external evidence and this and that, the truck traffic seemed to be something that was seemed clearly to be external evidence of the activity, which is referred to in section 32529, and it's measurable. So it's something that both comports with the part of the law that talks about external evidence, and it's something that can be counted and objectively measured. So it seemed, again, this is what the council, if the council adopts it, say, look, this is a way that actually makes sense, that it can be measured, and it comports and is consistent with the existing things that are in the law. And that's what it would do. And so that's just saying, well, these are things that are objective, they're measurable, and this is what the council would say that you ought to look at. The numbers would be based on what you come up with, if that's what you go with. It could be what was found here. If you have evidence, it actually refers to, if there's evidence for other numbers, those are fine too. But it does say this is what if it were to pass, the council say, well, these are things that you can actually measure. We have some data on it. It allows for a somewhat reasonably objective standard as opposed to other things that might be more difficult. And that's what the point of it is. Otherwise, the question will come before you have to figure out how to apply it, what to apply, and then also the objective components of that. So this says, here's how to measure it, and leaves it up to you to come up with the measurement. But it also says, notwithstanding whatever you come up with, you can still go up to 10,000. Otherwise, it will come back to you and you say, well, we have to find both factors to figure out what the standards of it are, and then find the facts to fit them. So this, goes partway to filling those things.
Let me pause the discussion for just a minute. We're up against 6 o'clock. We did post public hearing at 6. So I just want to poll the citizens that are here. Are there folks here that are to speak in the public hearing for the Edwards Elementary School project? 1, 2. Linda, have you got a sign up sheet? So I just need to ask, would you give us permission to continue this discussion for 15 minutes? And then we'll move into the public hearing?
Sure.
Okay, great. Thanks. So let's put a 6:15 stop time on this. And
Yeah, and so, and that's really kind of where it stands, is that, this lays out reasons, it said, starting going back to the beginning, if the court sends it back, you're gonna have the question. They will, because the relief that's being requested is to come back and as such use existed in 2000. So you're gonna have to deal that question. If you don't have it, you're gonna say, well, what does that mean? And in the sort of the findings and purpose, this lays out an approach to that question. What does that mean? And it tries to look at the existing code, look at the references, look at the things that already existed and work with those. If those, are rational reasons perhaps to do it, but you might come to, you might come to the same conclusion on your own. This is the way it's being looked at by the council. Whether they adopt the law or not, you may come to look at the same thing. So yeah, that actually makes sense. And this is what it should be. And maybe you don't find that. But then when it's determined how to evaluate it, then you need to find facts, data measurable things that you can apply to that framework.
Ben, let's see if we have any more questions or comments from the board.
No.
So, I mean, my quick take on this is that we have a journey ahead of us as a city. And that journey is going to be a challenge. It's going to challenge our individual and our institutional abilities to conduct complicated business. And anywhere we have an opportunity to clarify where there's ambiguity, that just helps clean the process going forward. But the process is going to happen. I sort of have a Rodney King hybrid philosophy here. Not can we all get along, but can we find a common ground that maybe we're not all happy with, but we survive a process that we can not be damaged by or injured by in the process. So wherever we can reduce ambiguity, we should try to do that. So specificity, measurable and not qualitative judgments. So that future planning board, whether it's us or some other group, one of the things I observed as a citizen last year was there did seem to be a lot of ambiguity about certain aspects of this. So I viewed this as an incremental step forward to create a more constructive environment for us to follow for this process that we have ahead of us. Certainly, Veronica, the issues that you may wish to raise and that have been raised by the county will be raised in abundance going forward in the process. So I guess my point of view is, can this planning board contribute to reducing ambiguity by creating more specificity? And if we're revisited by this application in the future, some of these questions have been resolved. So basically, I guess what I'm doing is compartmentalizing a little bit, Veronica, and saying, we can't solve the whole issue tonight, but maybe we can address some individual details that will help make future meetings and future hearings easier to deal with.
I don't know why you said that to me. I'm not.
Well, it's just,
I
yeah.
understand that statement.
This is not supposed to be creating new restrictions.
Yeah.
We actually don't think that would be appropriate. It's what does the law already say? And how can you actually put that into measurable, objective terms where there is information to verify it? So that's what its purpose is.
So the Public Council is asking for an advisory opinion. They are not asking us necessarily to vote it up or vote it down. And one thought that I've had is that we offer an advisory opinion. And that based on this discussion and perhaps other discussions that we might have, we construct a letter and send it to the Common Council with our point of view. It's not a voted up, voted down. It's simply, you ask for our advice on this. Here are some of our thoughts that we have. I'd be happy with the board's authorization to draft, based on this discussion, to draft a letter for us to look at our next meeting and for amendments, changes, and approval. And then we can move on to other business. If that seems like a reasonable step, I'd be interested in your reactions.
Yeah, that seems reasonable. But based on the presentation, so well, my concern was that they were going to use, like they're trying to make amendments to the laws that we have to, they're basically going to revisit, like permit, but through with certain amendments, but that doesn't seem to be the case based on what you presented.
This would have no effect and will never have any effect unless the court sends it back and says, you need to answer this question. Because if it doesn't send it back, the existing permit's in effect and it's in perpetuity, and it can't, it can't half in fact, can't come in and start changing around and saying this, that, or the other. But it is about that. If the court sends it back, how are you going to answer the question? Right. It's a responsive thing.
So the court is doing it based on existing or not necessarily any, because I know that there's thoughts about trying to make changes. It's not going to be.
No, that is not within the purview. The question, the words are already there. That's when it says, when it has the words in the existing code about as such as existed, it has things about, no external evidence. Those are already there. And this is like, put meat on those bones. It is not well, we think they should do this, we think they should do that. That's off the table. It says, how do you answer the existing questions? It may happen, it may just, and if it doesn't, if the question comes back to you, it's all in your report, the entire thing.
But that could lead to more ambiguity.
So
One lender.
that's the key thing, is that the question comes back. It's not, we don't, the common council don't have any authority for whether or not the question comes back to you. If the report sends it back, it does. If they don't, it doesn't. What happens when it gets here? That's sort of what this is attempting to do.
Other discussion, questions? Thank you.
I have one very narrow technical bit of feedback, which is that the Hall Road, permit has a trips per day number. And I think that's actually a better requirement in terms of the number, if you're actually looking into that impact, because, there's a good part of the year when the dock is not in operation. And so if you actually are looking at trying to minimize impacts, it's like the per day during the summer.
Well, that's to answer, I would say a couple things. One, that's a great comment to put in. But secondly,
Yeah.
this law is not intending to limit impacts. It is attempting to define what the code already says. So that's why it isn't trying to do that.
Okay.
And it's trying to think, how can we measure
Yeah.
what is already there? And then so, but I mean, that's a comment, that's the kind of thing you want to put in there. But it is important to understand that it's not trying to essentially achieve new things, or it's trying to just answer the question what's already there.
And then I have just like one, like, I think I disagree about your assertion that quantitative is better than qualitative in terms of the code. And that, like, the job of the planning board, as I understand it, is to, in a semi-judicial way, interpret the code using evidence that we find out in the world. And that anytime there's like a restriction in that, or narrowing, I know that I share your assertion, that's a good thing. Versus like allowing the board to use own findings of facts and own interpretations of reality rather than that being narrowly constrained in the code itself. So that's my one sort of disagree with your statement.
Gene, any comments? So we have a couple of options. We can move to reject, we can move to approve, or we can simply say, we'll conclude this discussion and do nothing. Or, you can authorize me to craft a letter that picks up some of these, comments, bring back to the board to review and approve, in the next meeting. Is there a point of view that someone would like to?
I would also just add, it's referred to you, if there's no agreement on, I mean, you can say, we have looked at it, but don't. That happens. That happens too. So I mean, you can write whatever you want. You can reflect individual members, say some members thought this, some members thought that. If there's a consensus you want to do, but you have a lot of flexibility to respond to this. It's just, there's a period of time in which to do it for the balance. So it's totally in your court, as you want.
So an alternative strategy would be that I draft something sooner and distribute it right away. So that if anybody wants to add feedback before the next meeting, I would give you an opportunity to do that. So with just a few minutes to go on this topic, what's
I just mentioned, there is a time period, just so you, from the time it was sent to you, I actually don't remember what this.
Yes, I do.
60 days when it needs to be back, or it's checked, or.
Are you saying you wouldn't receive a letter from the planning board if we send a letter?
No, I'm just saying, it's supposed to be done. I don't remember exactly when.
30 days.
Yeah.
30 days.
So I mean, you can't sit for 3 months or whatever, because there's a time period. Yeah.
So the scenario that I'm suggesting is that the board doesn't vote to approve or disapprove. We write a letter that expresses some of our advisory opinions. And we send it, after the board approves it, we send it to the common council. We're not taking comments tonight, Margaret. Sorry.
When you say advisory opinions, where are those our opinions or someone else's opinions?
Well, I think through the lens of your opinions, through the lens of your planning board perspective, yeah. Thoughts.
Not everyone has spoken. I mean, like, I don't really know how this is going to be a letter that, without voting or without us discussing, it sounds like it's going to be kind of the perspective of a few people.
What I'm hearing is that Ron's gonna draft a letter, we will discuss it and approve it at the next meeting, and hopefully you could circulate it well in advance so that we could, yes, Supreme Court style, both speak as a board and speak as a committee.
Yeah, I think you can include.
Thank you, sir.
You don't have to include just consensus. I mean, it can include alternative, other, say, a couple members raise this. So it doesn't have to be a big vote. It's trying to get feedback.
Yeah.
Constructive feedback is the point. And it's supposed to go to the board for discussion.
So I think, I don't know whether your 30-day limit anticipates the action that we're discussing. But if we write a letter that it exceeds the 30-day time limit, what are the implications of that?
It's just that under the code, the common council can't vote on the local law until that time period has run. So when there's a proposed zoning law that has to go to the planning board, common council has to sit for that period until either the time period runs out or the board responds. So it would just mean that if the common council got to the point where they're prepared to vote on it, they need to either refer it back from the planning board or the 30-day time period for referral has to go back. If this goes on for a few more months or whatever, and you were outside the time period, you sent a letter, it would still be reviewed and valuable. It just, in the same way when something is sent to the county planning board, there's a statutory thing that is a 30-day period that has to, you have to wait 30 days of sending it before you can act. So that's what it needs to, and I'm not sure the date when it was deferred, it's that, but it would still be considered if the law hasn't been acted on, but the common council cannot act until that time period's passed.
So, Chair would entertain a motion that I be authorized to draft a responsive letter to the common council. I'm framing it as an advisory opinion, picking up on the discussion we've had tonight, distribute it to you individually for your review and additional comments before the next meeting. I'll incorporate those into the letter so that when you see the letter, it will reflect your comments. I'm not suggesting we attribute comments to individuals, but that we're speaking as a board. And I think that it can be a balanced statement that represents a variety of points of view, and that we have satisfied the request. And so a motion along those lines would be helpful.
So moved.
Thank you, Sarah.
I was subject. If you draft the letter, we're gonna review it, give a sample list. Check, poll the board as to whether or not they're ready to move on. To take a vote to approve this or not approve it. So you don't waste your time, don't waste your time drafting a letter.
Is the question whether this board would be ready to,
Ready now to say, yes, we approve this, no, we're gonna approve this.
or you take, or the board takes everything?
Well, first of all, you're not voting to approve or disapprove. It's a feedback of advice and guidance. So it's not, you're not voting on whether to approve or disapprove the law. I mean, you could do that, I suppose, but that's not primarily it. It is your comments and thought and guidance. It's an advisory opinion on what you think of it. And so, it's only, you can have a lot of different opinions. You can do whatever you want, but it's not there's no requirement for any kind of up or down.
Got it. So we have a motion on the floor. Is there a second?
Second.
Call the roll, please.
Counselor,
Are we,
Rocco's not going to draft the letter.
okay, are we taking into consideration voting, if we're recommending, not recommending, I don't know. No, okay, yeah, then yes.
Yeah, I don't think you're recommending for or against it. You want to express your concerns. So maybe you want to add to that. And remember, give your concerns to Ron for him to draft. And then it goes out to you. So then the letter going to the common council can be, here's the concerns. Here's our thoughts and concerns. This is what we might find confusing or what we might find good about it. Or I think that's what they're looking for.
I think at one point there has to be either we recommend, we don't recommend, or no opinion, or whatever it is.
Yeah, I'm just saying, I do other municipalities, we do these all the time. And the responses vary tremendously. Sometimes they'll just say, we don't really have an opinion, do what you want. Other times it will be just a very limited technical thing. It's like, you know, this sentence here maybe should be clarified. Other times it will be really substantive. It's like, well, this is going to affect, you know, the farmland and blah, 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 or, you know, how is this going to, you know, it may be a really substantive response. So every case is different, but it's, what are things that come to mind that you think the legislative body ought to think about? Whether that's flat, don't do it, do it, or we are concerned about this, we think this isn't clear, we think it may have this impact that you should think about. You know, it's a very open slate.
Just
for
a
you
point of
guys.
order, we're in the middle of a vote, and the discussion has ceased, so we need to get back to the vote. Linda?
Black,
Yes.
Bolton,
Yes.
Chetsky,
Yes.
Woodall,
Yes.
Spear,
Yes.
Michael.
Yes.
Motion passed. Thank you, Ken. Really appreciate you being here. I know there are a number of other folks in the audience tonight that have got a deep interest in this. And I'm sorry we don't have public comments at our regular meetings, but thank you for being with us tonight. With that, we move directly into the next order of business.